Hi, this is Dan Smith of DPS Legal Counsel, and welcome to today's video and podcast episode of Legal Scrubs, where I talk about the business of healthcare. So today I want to talk about one of those documents that you may have heard of, but may not know what it means in the context of selling or buying a medical practice. And that term, that document, is letter of intent. So what is a letter of intent, and how is it used in the sale and purchase of a medical practice? Well, a letter of intent is essentially a preliminary agreement that is non-binding in nature, that sets out the basic skeletal terms and conditions of a transaction, of a business transaction. And so a typical letter of intent will provide who the parties are, who's the seller, who's the buyer. It'll provide what's being sold and what's being purchased. Is it going to be all of the assets of the medical practice, only certain assets of the medical practice, excluding, let's say, accounts receivable? Is it going to be the sale and purchase of stock in a professional corporation rather than the assets of the practice? Or is it going to be the purchase of the membership interests of a professional limited liability company rather than the purchase and sale of particular assets? So you have parties, you have what's being purchased and sold, and you're going to have purchase price. Is it going to be X amount or Y amount? And how's it going to be paid? Is it going to be paid all at once or partly at the outset and then over time with a promissory note? Is the doctor or doctors who own the practice, are they going to continue on in some kind of transition period with the new practice, or is it going to be a clean break, the sale takes place and they are no longer affiliated with the practice? Are the staff members going to be retained or not retained? All kinds of issues that would be addressed in a lengthy and definitive purchase agreement. You kind of deal with in skeletal form in a letter of intent, basically just setting forth what the general terms are that the parties expect to be in a final agreement. Now, most letters of intent are, and they should be, non-binding. In other words, this is just a preliminary agreement to agree in the future on specific terms. And so you want to provide in your letter of intent that it is non-binding. Essentially, the parties are agreeing to negotiate further and to come up with a final agreement. And so the letter of intent should provide that it's non-binding except for certain specific provisions which should be binding. Typically, what provisions in a letter of intent are binding are, number one, the requirement that the parties keep each other's confidential information secret and confidential. Because what's going to happen is that as part of the due diligence process, information is going to be shared between the parties. And you want to be able to share that information as part of getting the deal done, doing due diligence, without the risk or fear that confidential information is going to get out and be shared publicly. And so there will be a provision typically in a letter of intent that information will be shared as part of the due diligence process, but it will be kept confidential. And that provision typically is binding. Another provision that typically is binding is that a certain period of time is set forth in the letter of intent for the parties to negotiate only with each other, an exclusivity provision, in other words, in which the parties are saying the seller won't sell to somebody else, the buyer won't buy from somebody else for some period of time in order to give the parties time to negotiate and try to come up with a final deal. And so typically a period of exclusivity is set forth in a letter of intent, and that provision typically is binding. Short of that, a letter of intent can provide all sorts of provisions. Whatever the parties have thought about, talked about, would like to include as a skeletal outline for what they think the deal is going to be, you can put it in the letter of intent. And again, typically a letter of intent is not binding except for certain specific provisions, and so it does give the parties the ability to walk away or to change the terms they may have put in the letter of intent, but it is crucial that the letter of intent provide clearly that it is non-binding except for the specific provisions that the parties intend to be binding. It's really, when you sign a letter of intent, you're signing a very important document, so it's important really that you have it prepared by and reviewed by an attorney who's familiar with letters of intent and with contract provisions, and who can advise you on what should go in and what should not go in to a letter of intent. All right, I hope that helps. If you have any questions, please feel free to reach out and give me a call.